Hello everyone, welcome to PW OnlyIAS YouTube channel. Hope you're all doing great today. And yes, we are here with the last and final part of the most important chapter, which is fundamental rights. So without any further delay, taking you right into the topic. And before that, this is my Telegram channel, people. Any queries that you have, you may send it over here. Plus, you can also send the 2013 onwards PYQs over here, which is of the subject public administration, because that is the optional that I teach, all the 4 GS papers and the essay paper. Clear? Please ensure that you're only sending the PYQs, not any other institute or academy's answers, neither any AI generated answers. Only and only the PYQs. So, shall we start, people? So, what we are going to see now is right to constitutional remedies. What do you mean by right to constitutional remedies? Right to constitutional remedies simply means if my fundamental rights are violated, then what will I do? Where will I go? So, to ensure that if the fundamental rights are violated, there should be some mechanism to ensure that some protection is there. And that protection is itself a fundamental right. So, Article 32 basically gives that right. The right to get the fundamental rights protected means if my fundamental right is violated, I can directly approach the Supreme Court. That is why it is called right to constitutional remedy. My fundamental right is violated, I directly go to the Supreme Court and I say, see, these fundamental rights of mine have been violated. Article 32, the right to get the fundamental rights protected, is in itself a fundamental right. Dr. Ambedkar called Article 32 as the most important article of the Constitution, an article without which this Constitution would be a nullity. It is the very soul of the Constitution and the very heart of it. Supreme Court, Article 32, called it as a basic feature of the Constitution. So Ambedkar told that it is the heart and soul. Supreme Court brought it under the basic feature. And it contains the following 4 provisions. Let us see what are they. Right to move Supreme Court for enforcement of fundamental right. You can directly move. Supreme Court has the power to issue writs, orders, directions, etc. to ensure that fundamental rights are enforced. Writs, habeas corpus, mandamus, prohibition, certiorari, and quo-warranto, which we'll be seeing in a while. Parliament can empower any other court to issue directions, orders, and writs of all kinds. What does this particular provision mean? That Parliament can issue directions, orders, or writs. It simply means Parliament can basically empower any other lower court for what? For passing any direction, order, or writs to enforce fundamental right, except the Supreme Court and High Court. Because Supreme Court by default has this power under Article 32. High Court also has this power under Article 226. Constitution guarantees these rights for Supreme Court and High Court. For the lower courts, if at all they want that power to give directions, orders, or writs for enforcement of fundamental rights, only the Parliament can pass a law enforcing it, not the legislature, state legislative assemblies. So, however, this can be done without prejudice to the above powers conferred on the Supreme Court. High Court will not come under this particular clause because High Court already has these powers under Article 226. The right to move the Supreme Court shall not be suspended except as otherwise provided for by the Constitution. Means what? If the Constitution says a process is there whereby which you are not supposed to be violating the fundamental right. Alright. Means what? It simply means only as per the provisions of the Constitution, fundamental rights can be suspended. Otherwise, no. Let us understand that Constitution provides that the President can suspend the right to move any court for the enforcement of fundamental right when during a national emergency under Article 359. That is the reason why Supreme Court is called what? The defender and the guarantor of fundamental rights of the citizens. It has been vested with the original and wide powers for that purpose. Original and wide powers. All right. That is the idea behind it. Why it is called original? Because an agreed citizen can directly go to the Supreme Court. That is why it is called original. Directly you can go there. Why it is called very wide? It is called wide because it is not restricted to issuing of orders or directions, but also writs of all kinds. Orders it can give, directions it can give, it can also give writs. Clear? Moving on. Article 32 cannot be invoked simply to determine the constitutionality of an executive order or a legislation. That is, you cannot use it arbitrarily for anything that the government will do or the parliament will do or the state legislative assembly will do. Whenever you want to invoke Article 32, it should be only on a case of what? Contravention or infringement of fundamental rights. Otherwise, you cannot use Article 32. The Supreme Court has ruled that where relief through high courts is available under Article 226, the aggrieved party should first move to the High Court. Makes sense? Otherwise, Supreme Court will only have what? Time to deal with such cases. So, Supreme Court basically told where relief is available under Article 226, you can approach the High Court first, means please go to the High Court first. But what if somebody directly moves to the Supreme Court for contravention of fundamental rights? Can Supreme Court say, sorry, you take it to the High Court first? No. Why? Protected under the Constitution. It's a right to move to the Supreme Court for the protection of fundamental rights. Taking it further forward, now moving on to what are the different types of writs and what is the scope? Let us look into that now. Habeas corpus, mandamus, prohibition, certiorari, and quo-warranto. These are the different types of writs that are available. Parliament can empower any other court to issue these writs. No provision is there. So far, only High Court and Supreme Court has this. We saw this already. Before 1950, only the High Court of Calcutta, Bombay, and Madras had the power to issue the writs. Under Article 226, now this power is there for all the High Courts in the country. That is to issue directions, orders, and writs for the enforcement of fundamental rights. It is borrowed from the English law where they are known as prerogative writs. The writ jurisdiction of the Supreme Court differs from that of the High Court in three respects. Let us see. Supreme Court, basically, if you see, Supreme Court can only use Article 32 for fundamental right, whereas High Court can use it for fundamental rights also, and normal constitutional law, legal law also. High Court can issue writs. Number two, it is with the territorial jurisdiction. That is, Supreme Court has the wider territorial jurisdiction. Obviously, it's applicable for the entire territory of India. High Court is only applicable for the territory of the state or the union territory. Then, a remedy under Article 32 is a fundamental right. And hence, Supreme Court may not refuse to exercise its writ jurisdiction. That is what I told you earlier. Supreme Court cannot say, go to High Court first and then come to us. No. It's a case of fundamental right violation. An aggrieved party can directly approach the Supreme Court. On the other hand, a remedy under Article 226 is discretionary, and hence High Court may refuse to exercise its writ jurisdiction. High Court can basically say, no, sorry, we cannot take this case right now. Clear, people? So this is the idea. Moving on. Habeas corpus. To have the body of. It is an order issued by the court to a person who has detained another person to produce the body of the latter before it. It would set the detained person free if the detention is found to be illegal. Thus, the writ is a bulwark of individual liberty against arbitrary detention. What does it mean? Simply means, let us say the police arrested an individual. The individual's family tried to go to the police station to see their son or daughter, and the cops are telling, no, we cannot show you now. All right, they are telling such things, they are selling that no, you cannot see now. We have transferred him to that jail, this jail, whatever. They are giving all tall stories. Basically, what the grieving family can do is they can straight away approach the High Court and file a habeas corpus there. That my son or daughter is illegally detained by the police. We need to see him or her. Police will have no choice but to produce the boy or girl there. Because once you file such a petition, High Court will look into the merits of the case and High Court will direct the cops to produce the person. All right. Now, let us say a lover, a boy, he feels the girl's family has kept her under lock and key. He has not seen her for months together. Can he go and file such a petition? Yes. He can file a habeas corpus, and again, the same thing will happen there. Court finds merits in it. Court will basically direct the parents to produce the girl there. Getting the point? The writ of habeas corpus can be issued against both public authorities as well as private individuals. The writ, on the other hand, is not issued where the detention is lawful, the proceeding is for contempt of a legislature or a court, detention is by a competent court, and detention is outside the jurisdiction of the court. Basically, what does it mean? You can only use it when the detention is unlawful. Legally, you are detained or you are under preventive detention or the court does not have any role there. In such scenarios, writ cannot be issued. Clear? Now we come to mandamus. Mandamus means we command. It is a command issued by the court to a public official asking him or her to perform his or her official duties that he or she has failed or refused to perform. It can also be issued against any public body, a corporation, an inferior court, a tribunal, or government for the same purpose. The writ of mandamus cannot be issued in certain conditions. What does it mean? Simply means asking a government body or a government official, do your job. That's what it means. Therefore, when it comes to habeas corpus, you can issue it against government bodies for produce. That is anywhere a person is illegally detained, against private individuals. When it comes to mandamus, you can clearly see you are directing a public official or a government department or public corporation or maybe even any other body under the government means you can use this particular clause if you feel they have not done their duty. Getting the point? But again, there are exceptions to this. You cannot use it against, obviously, a private individual or body. To enforce departmental instruction, you cannot use this when the duty is discretionary and not mandatory. To enforce a contractual obligation, it cannot be used on the president or the state governors, nor on the chief justice of a high court acting in judicial capacity. So under these conditions, you cannot use it. And normal routine administrative affairs also, you cannot simply use mandamus. Mandamus purpose is very, very clear. Officially, you were supposed to do something. You didn't do it. You refused to do it. If there is a critical security issues, national threat issue, that is all different. Those are exceptional cases. But on a normal routine basis, you are supposed to be giving an approval or something. You are refusing to do it. You are telling, no, I won't give approval. You do whatever you want. Such a scenario, you can take that concerned government official, drag that person all the way to the court. Clear? Then comes prohibition. Prohibition means what? Basically, forbid. That is to stop somebody from doing something. Now, prohibition, you should understand, it is generally used in the legal context. Legal context, when I say either a judicial body or a quasi-judicial body. How? It is issued by a higher court to a lower court. Understand, when you say higher court, it does not mean high court. This particular fundamental writ, this writ basically can be issued by the Supreme Court to the High Court. High Court can issue it to the lower court. That is how it is. A court higher than you is issuing it. Clear? Or tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. That is, you're going beyond your mandate. High Court is looking into a case which does not comes under its jurisdiction. Supreme Court will ask it, stop. Please stop your proceedings. This will come under my jurisdiction. I will take care of it. Or lower court is giving verdict in a case, is basically listening to a case which will not come under its jurisdiction. High Court can tell, stop. This does not come under you. This comes under me. Give it to me. That is prohibition. Mandamus directs activity. Prohibition directs inactivity. So mandamus is basically used against government officials and forces the government officials to do your work. Prohibition basically tells to stop doing whatever you are doing right now. To whom? judicial or quasi-judicial bodies. It is only against judicial and quasi-judicial authorities. It is not available against administrative authorities, legislative bodies, and private individuals or any other bodies. Then comes certiorari. Certiorari means to be certified or to be informed. It is again issued by a higher court to a lower court or tribunal to quash the order passed by the latter in a case. What does that mean? Certiorari basically tells the lower court. Alright, Supreme Court can tell it to High Court can tell it to lower courts. Basically, that is, you have passed one order in the earlier case that does not come under jurisdiction. Whatever order you passed, quash it. What does this mean? Let us say I got to know, okay, I am the Supreme Court. You are the High Court. I got to know you are listening to a case which will not fall under your jurisdiction. Then which one will I use? I will use for prohibition. I'll ask you to stop the case then and there, and I will take up the case. That is prohibition. Let us say, now scenario 2. You are the High Court. You were listening to a case, you finished the case, you heard the hearing, everything, and then you passed an order. After you passed the order, I got to know about this issue that you have passed an order in a case which is beyond your jurisdiction. Now what will I tell you? I will tell you, quash that order. That time I will use certiorari. Getting the point? One is when the proceedings are still happening means I will use prohibition. Stop. Give it to me. The other one, certiorari is what? Certiorari is the proceedings are over. You have given your order also. Then I am telling you, stop, quash your order. That order is no more valid. I will listen to this case now. Getting the picture here? So once again, certiorari is also used against whom? Quasi-judicial bodies and judicial bodies. It is used on the grounds of excess of jurisdiction or lack of jurisdiction. Thus, like the writ of prohibition, writ of certiorari is also a jurisdictional writ. However, they are issued at different stages of proceedings before a lower court or tribunal. Prohibition is issued before the final order is passed for stopping the further continuance of the proceedings, whereas the certiorari is issued after the final order is passed for quashing the same. Once again, it is only used against judicial and quasi-judicial authorities. Certiorari is also not available against administrative authorities, legislative bodies, and private individuals or bodies. Clear, people? Moving on. Quo-warranto. Quo-warranto means by whose authority, by what authority, or by whose orders. By what authority or warrant. It is issued by the court to inquire into the legality of claim of a person to a public office. Clear? Prevents illegal usurpation of public office by a person. This writ can be issued only in case of a substantive public office of a permanent character created by a statute, that is law, or by the constitution. That simply means anybody who is sitting in a government office. By whose authority, by what warrant, or by whose authority have you been appointed here? Getting the point? When any government office, if you go, there will be something called as reporting officer or appointed authority. Who has appointed you there? The one paper you will get. One order copy you will get. So that will show appointed by whom. It will be clearly given. So that is your appointment order basically. So quo-warranto basically is asking, where is your appointment order? It cannot be issued in case of ministerial office or private office. This writ can be sought by any public-minded person and not necessarily by the aggrieved person. Any public-minded person can ask this question. It is not necessarily that I should be a victim here. Anybody, if they have a doubt that this person does not seem genuine, who appointed him here? On whose authority this person is here? Anybody from the public can put up a question there. Taking it further forward, armed forces and fundamental rights. When we talk about armed forces and fundamental rights, you have to understand one thing here. Armed forces, that means people who carry weapons with them. Do they have the right to talk whatever they want? Do they have the right to join any association they want, form groups and all? No. Why? To ensure discipline. So as a result of which, the normal fundamental rights that is there with a citizen, like say Article 19, freedom of speech and expression, freedom to move anywhere you want in India, that and all is not there for armed forces. Why? If I tell you that this is your area, you have to be posted here. I cannot tell that time. This is my fundamental right. I will keep moving wherever I want. No. Because to ensure discipline, ensure the integrity of armed forces, you need this exception. Getting the picture here? So let us go into that. Article 33 empowers the parliament to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies, and analogous forces. The power to make laws under Article 33 is conferred only on the parliament and not on state legislatures. Why? You need uniformity throughout the country. Any such law made by parliament cannot be challenged in any court on the ground of contravention of any of the fundamental rights. Why? What is the reason? Like I already told you, the reason is only one thing, that is discipline. Accordingly, the parliament has enacted the Army Act, the Navy Act, the Air Force Act in 1950, the Police Forces Restriction of Rights Act 1966, the Border Security Force Act, and so on. Restrictions largely on Article 19 it is. That is the right to speech and expression, right to form association, right to settle or reside anywhere in the territory of India. In all these restrictions are there when it comes to armed forces. The expression members of the armed forces also covers such employees of the armed forces as barbers, carpenters, mechanics, cooks, chowkidars, bootmakers, tailors who are non-combatants. That is, even if you are not carrying a weapon, doesn't mean that you're not part of the armed forces. Because even if you're doing any of the role, but you are under the army payroll or paramilitary forces payroll, you are also bound by the same set of restrictions. A parliamentary law enacted under Article 33 can also exclude the court-martial tribunals established under the military law from the writ jurisdiction of the Supreme Court and the High Court so far as the enforcement of fundamental right is concerned. What does that mean? Whatever court proceedings happens inside a military court, you cannot take that ruling from the military court and go and challenge it in a Supreme Court and a High Court telling that my fundamental rights is violated. Military court is for military itself. They have their own set of rulings there. Getting the point? Their punishments are severe, strict, and it's like to the point. Like how to put it in Hindi, seedhi baat, no bakwas. It is not that the case will get dragged by 20 years, 30 years and all. Complicated case may get dragged by maybe months, maybe maximum by a year or two. But generally they will wind up their activities at the earliest. No drama, no melodramas and all. Taking it further forward, martial law and fundamental rights. Article 34 provides for the restrictions on fundamental rights while martial law is in any area within the territory of India. Restrictions on the fundamental rights when martial law is in place. Martial law means military law. Simply means there will be no government, there will be no ordinary courts. Military will take over all the administrative activities. Simple. Military will take over. It empowers the parliament to indemnify any government servant or any other person for any act done by him or her in connection with the maintenance or restoration of order in any area where martial law was in force. That simply means it does not mean that all the government servants will be dismissed. But government servants or anybody, anything that you do, you are governed by the military law. Military law will be the basic structure that everybody will follow. And whatever you do, whatever you say, whatever you do, whatever act is committed, omitted, whatever is done, when martial law is in place, Parliament can basically pass a law indemnifying. Indemnifying means absolving the government servant of everything. That is basically, even if the government servant did something wrong, knowingly or unknowingly, you cannot put a case on him or her. The parliament can also validate any sentence passed, punishment inflicted, forfeiture ordered, or other act done under martial law in such area. As you can clearly see, once again, even with regard to martial law also, only who can pass laws? Parliament. Clear? The act of indemnity made by the parliament cannot be challenged in any court on the ground of contravention of any of the fundamental right. You cannot do it. Clear? Moving on. The concept of martial law has been borrowed in India from the English common law. However, the expression martial law has not been defined anywhere in the constitution. Please keep it in mind. It refers to a situation where civil administration is run by military authorities according to their own rules and regulations framed outside the ordinary law. It thus implies the suspension of ordinary law and the government by military tribunals. They'll suspend everything. It is different from the military law that is applicable to the armed forces. Clear? That is, here now military will run things, the entire administration. They will take over everything. But this is different from what? Military law. Why? Military law means how the law basically that is used to control the armed forces, everything. Here we are talking about civic administration entirely being taken over by the military. There is also no specific or express provision in the constitution that authorizes the executive to declare martial law. That is, constitution doesn't say under what circumstance can you declare martial law in the country. That is not clearly defined. However, it is implicit in Article 34 under which martial law can be declared in any area within the territory of India. Martial law is imposed under the extraordinary circumstance like war, invasion, insurrection, rebellion, riot, or any violent resistance to law. Implicitly it is mentioned when, under what condition can you declare martial law. Its justification is to repel force by force for maintaining or restoring order in the society. Too much of violence is there. Bring in the military, solve the problem. Once everything is restored, military is pulled back, normal government, administration, everything is restored there. During the operation of martial law, the military authorities are vested with abnormal powers to take all necessary steps. They impose restrictions and regulations on the rights of civilians, can punish the civilians, and even condemn them to death. Basically, they can kill also if it is necessary. Because military, when you call once the military there is no middle path. It is either you follow our rules or you will be buried. That's how military functions. There is no middle path there. Either listen to us or face the consequences. Taking it further forward. The Supreme Court held that the declaration of martial law does not ipso facto result in the suspension of the writ of habeas corpus. Important point. Whatever fundamental rights you say it is getting suspended, it is okay. Except what? Habeas corpus. Illegal detention cannot be entertained. They will have to prove that this person, has been killed or has been arrested for what? Under what circumstances? The declaration of a martial law under Article 34 is different from the declaration of a national emergency under Article 352. How? Martial law, if you see, it only affects what? It only affects the fundamental rights. Whereas when you have a national emergency in place, it will affect fundamental rights, center-state relations, legislative powers between the center and the states, as well as the revenue sharing. Then martial law will suspend the government as well as ordinary courts. Military will take over. Whereas in the case of national emergency, everything will be still continuing as it were. Martial law, it will restore breakdown of law and order. That is their main purpose of bringing them there. Alright. National emergency, why they will be brought in, when they will be brought in? During war, external aggression or armed rebellion. Martial law, it is only for a specific area. It is declared. National emergency, it can be for a specific area, part of a country, entire country also. Then it is implicit and there is no specific provision. That is, we understand that during war or breakdown of law and order, extreme level of violence, riots, that time you can bring it. But specifically, there is nothing mentioned in the constitution when it can be done. Whereas, in the case of national emergency, specific provision in the constitution as to how it can be declared, what are the steps involved, how it's important to get cabinet approval, then the parliamentary approval, all that is given very, very, very clearly. Entire steps is very detailed when it comes to the declaration of national emergency. Moving forward, affecting certain fundamental rights. Article 35 make laws only with parliament. Means what? As per Article 35, only Parliament has the exclusive authority to make laws with regard to residence as a condition for employment or appointment under Article 16, empowering courts other than the Supreme Court or High Court to issue writs as per Article 32, restricting or abrogating fundamental rights for armed forces under Article 33, indemnity to government servant for any act done during the operation of martial law under Article 34, passing laws to prevent untouchability or traffic in human beings and forced labor under Article 33. In all this, only Parliament can pass the law. Any law made before the commencement of the Constitution with regard to the above subjects also, that law will continue to remain in existence until and unless Parliament amends or repeals it. That means what? State Legislative Assembly does not have any powers with regard to this. Clear? Only Parliament has competence to make laws on the above subjects, even if some of them fall under state list. Clear? With regard to above subjects, even if it infringes on the jurisdiction of the state also, doesn't matter. Only Parliament has the law to pass any law. I mean, Parliament has the right to pass any law with regard to the above subjects. All right, people. Moving on. Present position of right to property. So I told you earlier, right to property was a fundamental right coming under Article 19(1)(f) and under Article 31. All right, where deprivation of your private property can only be done as per law. Acquisition should be done only for what? Public purpose, and adequate compensation should be given. However, the 44th Amendment Act basically abolished the right to property and repealed Article 19(1)(f) and Article 31. Today, under Article 300A, it is present in under Part 12. That is, it is no more a fundamental right. You can call it a legal right. You can call it a constitutional right. And any change you want to make here in 300A or in the Part 12, you don't require a constitutional amendment. Simple amendment is enough. Private property doesn't have protection against legislative action. It only has protection against executive action. Means what? If Parliament or the Legislative Assembly sits together, passes a law to acquire property of a region or of an area where people are living there, then there is no protection. There is no protection against legislative action. That is what it was there in the Constitution. But you must recall one thing, very recently Supreme Court made a change to this also. How? That is very clearly state should mention. The Legislative Assembly or the Parliament should make it. Whichever law you are going to pass to acquire private property, even if government is planning to acquire it, you must very clearly specify for whom it is that you are acquiring this property. For whom? Is it really for public service? Is it really for the community? Is it really a resource here? That should be properly defined. That means now the responsibility is on the state to prove that it is for a larger public purpose. It is for a larger community purpose. That should be specified there. This ruling is very, very important, I would say, because this has elevated this right. The right to property, it was always a constitutional right. Agreed. But now it has almost got elevated to the status of what? Like a fundamental right only. I'll tell you two reasons for it. See, every fundamental right is only qualified. Correct? It is only qualified. That means reasonable restrictions can be placed on it. Correct? It cannot be denied arbitrarily. Only by law it can be denied. Correct? Constitution has mentioned under what conditions fundamental rights can be suspended temporarily. Tell me how right to property is also very different from that now. So by default what it is now, my right to property is guaranteed. Only under exceptional case of, what is it? Right to purpose. That is not right to purpose, the public purpose. Or how it is a community resource. This has to be proved by the state in the court. Agreed. It won't be a fundamental right at all. You cannot say that it has become a fundamental right. Why? I cannot directly approach the Supreme Court. Agreed. So it is not a fundamental right. That is the other side of the view. But I can easily approach the High Court. I can easily approach the High Court and say, as per the current Supreme Court ruling, what is the public purpose here by acquiring my property? How is it going to be a resource of the community? Please tell me. I can easily go and pose a question. And if the state does not have enough logic or merit or facts to prove that there is a public purpose here, or it is indeed a community resource, what will happen? State will not be able to acquire my land. Even if they pass a law also, it is of no use. So that simply means now right to property is what? It's literally getting protected. Your property cannot be taken even by a legislative action also, because the public purpose resource that needs to be defined very clearly by the state. That is the long and short end of the recent Supreme Court verdict. Clear, people? Can't move to Supreme Court under Article 32, but you can move to a High Court under Article 226. There is no guaranteed right to compensation. That is not there. That is true. Because the guaranteed right is not there, that you will be compensated. No. It depends again on the situation. Moving on. Compensation for land of minority and land under personal cultivation. That means two exceptions are there. If that land belongs to a minority, then it is eligible for compensation. If it is under personal cultivation means, then again it is eligible for compensation. Moving to our next topic, which is exceptions to fundamental rights. What are the exceptions? Saving of laws providing for acquisition of estates. Article 31A saves 5 categories of laws from being challenged and invalidated. And what are those? Acquisition of estates and related rights, taking over the management of properties by the state, amalgamation of corporations, extinguishment or modifications of rights of directors or shareholders of corporations, and extinguishment or modification of mining leases. With regard to these things, even if fundamental right is violated also, you cannot approach a court. These 5 things, they are exceptions. Article 31A does not immunize a state law from judicial review. Means what? Even if you pass a law here, all right, you cannot say that Supreme Court will not check the law. No. Because judicial review is part of the Constitution. But what is the limit on Supreme Court or High Court, whatever? The limit is that the court will only look into the procedure established by law. That is, with regard to these 5 categories, arbitrary action will not be entertained. Whatever they are doing with regard to these 5 categories, it should be according to a procedure established by law. Otherwise, it will be struck down. Does not immunize a state law from judicial review unless it has been reserved for the president's consideration and has received his or her assent. So only exception is when it is under president's consideration and has also received his or her assent. That is, at the highest level it has received an assent means then nothing doing. But otherwise, an arbitrary action, if it is done by the state for these 5 categories, not according to a procedure established by law, it will be subject to judicial review. Court will question it. Taking it further forward, validation of certain acts and regulations. Article 31B saves acts and regulations under the 9th schedule. That is, if I want a particular act to be immune from judicial review, all I will do is pass the act and then place it under what? 9th schedule. But in the Keshavananda Bharati case and the Vaman Rao case, acts and regulations included in 9th schedule were subject to judicial review. Cut-off date was also fixed as 24th April 1973. Why? That is the date for your Keshavananda Bharati case verdict. That is, judicial review is part of what? The basic structure of the Constitution. So you cannot say this act is immune just because you have placed it under 9th schedule. In the I.R. Coelho case, Supreme Court reaffirmed the above. Judicial review is part of the basic feature. Cannot be taken away by putting any law under 9th schedule. It is open to challenge if it is violative of Article 14, 15, 19 and 21 or basic structure of the Constitution. Clear, people? Moving on. Saving of laws giving effect to certain directive principles. Article 31C. So under this, No law that seeks to implement the socialist principles specified in Article 39B or C shall be void on contravention of Article 14 and 19. Means if I am giving effect to Article 39B and 39C, then even if a violation of Article 14 or 19 is happening also, it won't be considered as a null law or a void law. Law will remain as it is, even if it violates 14 and 19. And what is Article 39B and 39C? State shall direct its policy towards securing that the ownership and control of the material resources of the community are so distributed as to best to subserve the common good. So if it is ultimately to serve the common good means, then no. Even if it violates a few people's fundamental rights also, that law will be not considered null and void. Number 2, the state shall direct its policy towards securing that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. You passed a law to prevent the concentration of wealth. Can you go and claim that my fundamental right under Article 14 and 19 has been violated? Again, the answer is no. So to give effect to 39B and 39C, even if fundamental rights under 14 and 19 is violated, the law will not be null and void. Taking it further forward, criticism of fundamental rights. Now, fundamental rights have been criticized for the following reasons: that it places too much of limitations on the state. State is not able to do anything. Then it only talks about political rights. There is no social and economic rights. Clarity is very, very less. There is a lot of confusion around it. Go to High Court, Supreme Court, all that. Parliament will make laws. There is no permanency. Right to property was a fundamental right. Today it is only a constitutional or legal right. Suspension during emergency. It can be suspended. Expensive remedy. Going to High Court or Supreme Court, single sittings there will cost lakhs together. Preventive detention still exists in our country, which is again violative of fundamental rights. There is no consistent philosophy in it because it keeps changing according to the situation. Right to property, again, as we know, earlier Justice Krishna Iyer had said that property in state can take it away at any time, including my car. If I have a car also, the state can take it away for public purpose. That car is also not mine. It can be taken away by the state. That is the ruling of Justice Krishna Iyer. When? Before 90s. Now after the LPG era, the current Chief Justice basically told it is no more the old era. We have come a long way forward from the socialistic era. Today, private property matters a lot. So arbitrarily, state cannot come and take away the private property telling that this is for a public purpose. This is a community resource. State will have to prove it. Whose public purpose? Whose community resource? Who does it stand to serve by acquiring it? Clear, people? So these are the criticisms. But does that mean our fundamental rights are bad or it is insufficient, etc.? No. Why? Let us see that now. What is the significance of fundamental rights? It is the bedrock of democracy. True. Without this, an individual will not be able to progress in life. Either material or moral progress. And for material and moral progress, what is necessary? Protection is necessary. It is the bulwark of individual liberty, establishment of rule of law. It protects the interest of minorities and weaker sections of the society. That means it actually gives voice to the voiceless. Strengthen the secular fabric of the nation. Check on the absoluteness of the government. That is, if the fundamental rights were not there, government will function however they want. Getting the point here? It is basically, it arrests the arbitrary usage of power not only by the executive but also by the legislature. Lay down the foundation stone of social equality and social justice. Ensures dignity and respect of individuals. Facilitate the participation of people in political and administrative process. Clear, people? Rights outside part 3. Rights outside part 3. What does that mean? Constitutional rights or legal rights or non-fundamental rights. 4 rights we are going to see now, which are constitutional. That means they are not part of your fundamental rights. They are there in the constitution. No tax shall be levied or collected except by authority of law. No person shall be deprived of his or her property save by authority of law. That means imposing a tax should be by law again. Taking away property should be by law. Number 3, trade, commerce and intercourse throughout the territory of India under Article 301 Part 13. The elections to the Lok Sabha and State Legislative Assembly shall be on the basis of adult suffrage. Article 326 Part 15. On all these things, again, you cannot move to the Supreme Court if any of these rights are violated. Why? It is not fundamental right. But can I move to the High Court? Yes. I can move to the High Court under Article 226. Clear, people? And that's it. Voila. We are winding up our 8th and one of the most important chapter. Any suggestions, any queries, people, you can access me here. Please put up your valid comments in the comment section also. Tell us how we can improve this. And I know those of you who are looking for the PDF of this material here, again, you can access it from this channel. All right, people. So with that, we wind up today's session. Hope you all had a great time. God bless. Take care.